So today we're going to talk a little bit about the courts and then shift gears a bit and talk about the Charter of Rights and Freedoms. So on our agenda, we have kind of the basics of the judicial system in Canada. Remember, we talked about 3 branches of government. We covered legislative in the first week. Then we talked about the Prime Minister and the Cabinet, who are part of both the legislative branch and the executive branch. Then we talked about the public service, which falls under the executive branch. So now we're on to that last branch of government, which is the judicial branch, and that is the courts. So we're going to talk about why we have the courts, talk about some of the different types of law we have in Canada, focusing on the Supreme Court of Canada, and then we will shift into the Charter of Rights and Freedoms. Where did it come from? What is it? What are the rights that are contained in there? So let's get started. So kind of a very basic question to start. Well, why do we even have courts? And so the question first is, well, what do they do? What's the point of having courts? So the first function is adjudicating legal disputes between private parties. So the idea behind governments are that really reasonable people get to decide and have somebody impartial to settle specific disputes. The second is to adjudicate cases in public law. So this is the ones like Queen versus X person. So it's when a person has a problem with a law itself. They don't think they broke it because it's an unreasonable law. So the courts might be asked to adjudicate that. They also run judicial commissions of inquiry. So taking over a commission into how a program is being run, why a disaster happened, that kind of thing. So for example, the sponsorship scandal, they got a judge to do that inquiry. And then the last one is judicial review of the Constitution. So does the Constitution allow something or prohibit something? And we're going to talk about that a little bit when we talk about the same-sex marriage law. So there's a few fundamental principles of having a judiciary. So the first is that it needs to be impartial. So there needs to be some scrutiny. You need to have a right to appeal, so a right to say, hey, wait a second, this was not run as it was supposed to. It needs to be adversarial in nature, so the judges are not necessarily involved in that adversarial part, but instead there's counsel for both sides who are arguing either sides of the debate. It needs to be politically neutral, so it's not tied to one particular political party or one particular political view. There needs to be equality before the law, and that's exactly just what it sounds like. So everyone has the same rights before the law. And then there needs to be judicial independence. So it needs to be independent of the executive branch so that they can tell them, what laws are being passed that are according to the Constitution that aren't. And also so that, the Prime Minister, for example, can't tell them what their salaries are going to be, can't fire them, can't organize their own courtrooms, etc. So there needs to be a firm sense of independence in the judiciary. So you might notice here, this statue, it's in front of the Supreme Court of Canada. And so this is a woman holding a 2-edged sword. And the idea is, that the law can be equal, that either side can win. And she's not wearing a blindfold, like a lot of you might have seen the statues of justice holding the scales and wearing a blindfold, the idea that justice is blind. But some suggest that this means that the Supreme Court, at least in Canada, must clearly see the consequence of the decision and be able to communicate them to the Canadian public. And so that's why justice in this case is not blind. So just a bit of symbolism behind that statue you might have seen before. So in Canada, we have 2 codes of law, so common law and civil law. So we'll go through that really quickly. I'm not a legal expert, but it's important to know civil law is used in Quebec. So it rests on a particular civil code based on the French system, whereas common law is used in the rest of Canada, and it rests on precedents. So it's based on judicial system. So precedents just means it's based on the other cases that have existed as opposed to being based on a particular written civil code. So it's important to remember that Canada has two systems of law existing because we obviously are based on both French system and British system. All right, so what's the structure of the courts in Canada? So the Supreme Court sits at the apex, sits at the top. It's the General Court of Appeal for Canada, so it hears appeals from the federal court and from the provincial court system. So in contrast to its counterpart in the US, the Supreme Court is a national court, not just a federal court. So it hears, it's kind of the final court of review. So the next courts down are the courts of appeal. And there are various provincial courts of appeal. You'll notice the Federal Court of Appeal also serves as the Court of Appeal for the territories. The next tier down are federal courts and superior courts in provinces. There's also a tax court. And then at the bottom is smaller provincial and territorial courts, things like traffic courts and small claims, family division, criminal division, etc. And then you guys would probably be aware of the military courts that also exist in Canada. So that's kind of generally how the structure works. So this is the court that's really at the top that makes the final decisions. It's the Supreme Court. So what is the Supreme Court? Where does it come from? So the Supreme Court of Canada was constituted in 1875 by an act of Parliament, and it's comprised of a Chief Justice and 8 other judges, all of whom are appointed by the Governor General, but on the advice of the Prime Minister. There needs to be a minimum of 3 judges coming from Quebec. The reason for that, of course, is they need to have people on the court who are really well versed in civil law. It's the General Court of Appeal for all other Canadian courts of law. And most cases, appeals are only heard there, though, if it's a question of public importance or raises an important issue. So it's not like if your traffic ticket, you can work your way all the way up to the Supreme Court unless it was an issue of public importance. It also has a special kind of reference jurisdiction. So the Parliament can ask for an opinion or an interpretation of the Constitution, and we'll talk about that in a little bit when we talk about same-sex marriage. But some people say these reference cases are sometimes used as a way to bypass making their own decisions, that Parliament might not want to touch a political issue and therefore just say, oh, well, let's get the Supreme Court to weigh in on this. So that's kind of the main purpose of the Supreme Court in Canada. So the Chief Justice up until December 2017 was Beverley McLaughlin. She really made quite an impact on the courts. So what I'm going to do is send you over to a video outlining her life. And then today we have Richard Wagner. And he's now the new Chief Justice of the Supreme Court. So head on over to the video about Beverley McLaughlin. She's quite a formidable woman and worth knowing a bit more about. So welcome back. So one thing that you might have heard of, especially in the American context, they talk a lot about judicial activism versus judicial restraint. So what exactly do those terms mean? Does this exist even in Canada? So judicial activism is this idea of using the court to make policy, that judicial rulings are really using the courts to make specific policies, to make decisions rather than using existing law. So the idea is that judicial rulings are being based on personal or political considerations rather than the existing law and interpreting that existing law. So the courts are making policy themselves. This is contrasted with judicial restraint, which is the idea that the court really has a limited amount of power, and that they really should hesitate to strike down laws unless they're obviously unconstitutional, and really just allow lawmakers to make laws that's not really their role. So to put all this to make a little bit of sense of all of this, let's look at a case study. So what I'm going to get you to do is head on over to the YouTube video about same-sex marriage. It's kind of an overview of what has happened from TV Ontario. And then we're going to talk about each of these discussion questions. So pause the video, go take a look at the same-sex marriage video. Link is in the description. And come on back and we'll discuss. So welcome back. So the first question we want to talk about is, how did this issue first arrive at the courts? So jot down your answer to that. And so we saw in the video that the Ontario courts that noticed that these couples that had been married weren't actually legally married. So the couples appealed to the Ontario Superior Court, which said that, yeah, the law does violate the Charter of Rights and Freedoms. The appeal court legalizes same-sex marriage immediately once it goes to appeal. So that's kind of where the issue first ended up in the court system, was in Ontario, was these couples who had gotten married, who had just done it and gotten married, and then challenged the law, really, that said that they couldn't be married. So what was the government's response? So really, the provinces didn't seem to want to deal with it, neither did the federal government. It was a politically contentious issue. I think a lot of you have just grown up in an era where same-sex marriage just seems normal. It was really quite a politically contentious issue that nobody really wanted to touch. Alberta said even if the Supreme Court ruled that it had to be allowed, that they would use the notwithstanding clause. So it was really something that the government was perhaps a little afraid of touching, because they knew that they would have great supporters, and then also people who would be very much not in favor of changing the law. So we saw a little clip, Harper arguing that it was undemocratic. So why is that the case? He was largely saying that the courts were essentially creating policy. When they said, yeah, actually this policy is against the Charter of Rights and Freedoms, they essentially forced the government to legalize same-sex marriage. And he argues that it's undemocratic because rather than going through legislative means, the courts made that policy. So this would be an example of, or he would say this is an example of judicial activism. Robinson, on the other hand, says the courts were actually working exactly as they should. So the courts were doing exactly what the legislator asked, and asking, which was to interpret the charter and make sure that citizens were protected against the government if they had legislation or laws that were against what we had decided as a Canadian population through the Charter of Rights and Freedoms should be allowed. And so in this case, Robinson said, no, the courts are doing exactly what they're supposed to do, what we've told them as a legislature to do. So how was this issue resolved? Well, the federal government asked the Supreme Court if they could rule on it. They were concerned it might be a provincial issue. And the Supreme Court came back and said yes. So Parliament drafted a bill and passed a law to allow same-sex marriage nationally. And so you can see arguments on either side in terms of judicial activism and judicial restraint. So some might say, well, the Ontario courts made something legal, so the courts were making policy, and this would be an example then of judicial activism. But you can also see an argument that this is actually a case of judicial restraint. So when it got to the Supreme Court as a reference case from Parliament, all that they said was, yes, it's within your jurisdiction, federal government, to make a law on this. It didn't tell them what that law had to be. So you can see both answers, that it's a case of judicial activism or that it's a case of judicial restraint. So it's usually not super clear-cut. So I think a couple more things before we move on to the charter more specifically. Going on with this idea of judicial activism there's some research that suggests that the courts have really become policymakers in their own right, and perhaps too activist. So Morton and Knopf wrote this book, The Charter Revolution and the Court Party. So the Court Party meaning it's just like a political party that's making decisions. So they argue that the Supreme Court has used the Charter to change government policy on issues such as abortion, Aboriginal rights, gay rights, bilingualism, prisoners voting, and that the courts really made themselves the second most powerful institution after the federal cabinet, after the executive. And so they say that behind this, though, is interest groups, that interest groups have started to use the court system as a way to achieve policy ends when they can't do that through democratic elections. And so it's not necessarily about the court making all of these decisions and being super activists. It's that interest groups have found that if they can't be successful lobbying the government, they can actually turn to the courts as a way to get things passed. There was even charter challenge funds, so resources to launch those long-term battles in the courts rather than focusing on lobbying. So that's one kind of scholarly interpretation of how the courts have evolved, especially in the era of the Charter. So another question that is often asked is, well, are courts undemocratic? And it's kind of a simple question, right? Because courts are the only branch that really aren't elected. We know that we have a fused legislative and executive branch, and the prime minister is elected in their riding. Even though he or she is not elected directly, they are still elected in some way. So the judicial branch is really, an undemocratic branch in the sense that it is not elected. The Supreme Court justices especially are just appointed by the prime minister, by the governor general through the prime minister. But what do you think could be some of the challenges if we were going to elect courts? So they do that, in some places in the United States, in some courts in the United States, they do elect their courts. So why might that be a problem? Some would argue that it could make the courts way too partisan, and that opposition parties would just start disapproving of anybody that the current government has brought forth, and puts it really into an adversarial political position like you see in the American system. So there's this question of how do we make the courts more democratic without actually electing them? So Paul Martin, Prime Minister, back before Harper, put in place a review process. So where committees had a chance to review nominations, and then Harper took that one step further by having a televised interview in front of the committee. And so it's a delicate balance of trying to allow for some oversight over who's getting onto the Supreme Court and not giving the Prime Minister free rein, but also recognizing the fact that we do need to keep the courts impartial, because that's one of those fundamental principles of the judiciary. All right, so now we're going to move on more specifically to look at the Canadian Charter of Rights and Freedoms. You've probably studied it before, but we're going to take a closer look at where it comes from, what it protects, what it doesn't protect, and that will lead into the activities that we're going to do this week. So how did we get the Charter of Rights and Freedoms? Where did this all come from? So post-World War II, and really the horrors of that war, led to the creation of the UN in 1945, the United Nations, and they passed a Universal Declaration of Human Rights in 1948. And this said that all humans had fundamental rights just by virtue of them being human, and that no law that a government makes should ever usurp those rights. So Canada's response to that, and Canada's commitment to human rights, was first through the Canadian Bill of Rights, which is passed in 1960. It was a federal law, which meant that it could get overturned and changed pretty easily. And it was difficult to enforce. And so what Pierre Elliott Trudeau did when he came into power and was interested in patriating the Constitution, or writing down a Canadian Constitution that you can see in this photo the Queen is signing in Canada, and for Canada. Trudeau brought a a new Canadian Charter of Rights and Freedoms that would be much more difficult to amend because you had to go through the constitutional amendment process, which we know, or at least we're going to find out soon, and when we talk about federalism, is very, very difficult to do. So 1982, we get the Charter of Rights and Freedoms, and the idea is to protect individual and group rights in Canada in a way that the government would have a really hard time taking those rights away, because it's not just any old law passed in Parliament, it is part of our Constitution. So I'm going to send you to a quick video so you can get a sense of what the Canadian Charter of Rights and Freedoms is. So pause, take a look at that. And now we're just going to head over to the actual Charter of Rights and Freedoms to talk a little bit about what it contains. All right, so first of all, right at the beginning, the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law that can be demonstrably justified in a free and democratic society. So this one we're going to talk about when we do the example or the case studies in class. What does it mean to have a reasonable limit? So this is a bit vague language, but it means it's open to interpretation. Anyway, so there are a variety of different types of freedoms enshrined in the Charter of Rights and Freedoms. So the first set is your fundamental freedoms. So these are things like freedom of religion, freedom of association, of assembly, of thought, freedom of the press. So those are all these fundamental freedoms that every individual has. The next section looks at democratic rights. So the idea that everyone has the right to vote, everyone has the right to be a candidate, and everyone has the right, and that the government needs to call an election every 5 years. So you might have heard about the Supreme Court deciding that this means that people living abroad should be able to vote because it says every citizen of Canada has the right to vote, right? It doesn't say where you live. So this was just very recently decided by the Supreme Court that this means that those outside of Canada should be eligible to vote. Now, you'll notice that this is enshrining this right to vote that was not actually a right to all Canadians until 1960. Some ethnic groups were not allowed to vote until 1960. So this is enshrined in the Constitution through the Charter of Rights and Freedoms now. Next, we have mobility rights. So this is the idea that you can come into Canada, you can leave Canada, you can move anywhere in Canada, just that you have a freedom to live anywhere in Canada that you would like. Legal rights, those are those rights, you can't have unfair search and seizure, you can't just get arrested randomly, although I think you give up some of these when you go onto a base, but these are all the cruel and unusual punishment. These are all regarding your rights, your legal rights. Equality rights, the fact that you shouldn't have any discrimination on the basis of race, national or ethnic origin, color, religion, sex, age, mental or physical disability. And you'll notice that there's a subsection that says that you can discriminate, but only if you're going to be addressing an underrepresentation or discrimination against a specific group. So it includes that clause in there too. Next, we have official languages. So English and French are the official languages, and it has some special things about New Brunswick as a bilingual province. And then down here, minority language education rights. So this idea that certain Canadians have a right to have education in either French or English. Now, this is about enforcement, some general stuff. The last thing I want to highlight is this part right here. So it applies to all of Canada, all of the provinces, with this exception. So this is what we call the notwithstanding clause. So this is so here's how this exception. Let's just highlight the whole thing. Yeah. There we go. So essentially the notwithstanding clause, you've probably heard of it before. So this is section 33. The idea is that provinces or the federal government can use it if they want to protect a law that might violate any of the fundamental freedoms, legal rights, or equality rights. So let's say that there's a situation where the government, any government, a provincial government or federal government, wants to pass a law or maintain an existing law. They're allowed to invoke this notwithstanding clause to disregard these charter protected freedoms. Where does this come from? Back when they were negotiating the charter, some supporters believed that the clause would give elected lawmakers some control over important issues, right? Because we talked earlier about how some people were concerned about judicial activism, and they wanted to make sure that power rested firmly within the hands of elected lawmakers. They did not want unelected judges to have too much power. And so the notwithstanding clause makes sure that ultimately power rests in the hands of elected officials. Those who were opposed to the notwithstanding clause, which included Prime Minister Pierre Trudeau, thought that it could really jeopardize the Charter's purpose, and it wouldn't allow the Charter to protect individual rights. But in the end, it was included to secure the province's support for the notwithstanding clause. It's very rarely used. The government has to have a really public policy reason to justify using it. And so it can be used when the government clearly states that the law is going to operate despite its potential violations to the Charter. And it can only last for 5 years, after which it can be renewed. So that's this 5 years part here. So as of May 2017, it's only been used 17 times by governments of Quebec, Alberta, Saskatchewan, and the Yukon. And we're going to talk a little bit more about the notwithstanding clause in your seminar this week. So let's go back to the PowerPoint presentation. So these are the rights in the Charter. All right, so I think the last thing that I really want to go over is this idea of individual versus collective rights, because we're going to address that when we get into the activity this week. So the idea of, oh, I don't know why there's multiple people here. I thought I'd put just one person. Anyway, regardless, imagine there's only one person right here. So individual rights are the idea that a right belongs to each person as a Canadian citizen or as a permanent resident. So that would be something like the freedom of expression, that I as an individual have a right to express myself. Collective rights, on the other hand, belong to a group of people, and they're written into the Charter for some of the founding groups in Canada, so Indigenous groups and specific language groups. So this would be like minority language education. It's important to understand that there are both individual and collective rights enshrined in the Charter, and that we can identify that some of them are looking specifically at the rights of groups, whereas some are looking specifically at the rights of individuals. All right, so that's what we have for today. So it's time to head over to the quiz and fill that out. And when we get into the class time, we're going to be doing a really good activity to really solidify what we've learned so far about the courts and the Charter, and also to talk a little bit more about these individual and collective rights and actually try our hand at adjudicating some of them. So head over to the quiz, and I'll see you in class.